Well, after one, do want to apologize to everyone. In the 2.5 years of running Zoom meetings, this is the first time my internet has literally gone out. I got a text from my provider saying it'll be back up at 3:07 this afternoon. So I have come to a different location that does have internet. And I want to give Ms. Burke and her witness the appropriate amount of time to potentially back up a little bit so that I didn't miss everything I may have missed. And I truly don't know where you were, I think, in terms of that. So I'll just let it be your call. You're not going to run into a time concern on that front. So Ms. Burke, the floor is yours with your witness. And actually, before you move forward,
we're also getting some feedback.
Great. Ms. Burke, are you able to hear me?
Yes, we're getting some feedback, Chair, but thank you. So I think we will, Ms. Denemy can pick back up and she'll do a very, very brief recap. I don't think you missed too terribly much, and then we'll move ahead forward.
And basically what I was trying to point out is that the substantial resources that Civitas has touted earlier today may not be what is available to them come the year of 2023. And that is across the board, not just with Civitas, but the Energy Information Administration is also projected that this year in 2023 will not be the banner year that last year was. The commission could even do their own financial review if they want to, using the Form 8s that are due today, that show what income that the company or multiple subsidiaries are reporting for 2023 and compare it to last year and see if they are in as good a position as they were in last year. Those Form 8s and the details for them are available at our website at COGCC. So that kind of item can be looked at. And what brought my concern was that I managed several royalty owners, and 2 months ago, the royalties for this one institution was 28 grand. Last month, they were 9,000. This month, they're 4,000. And that trend seems to be continuing based on what the EIA has put out there as potential dollars that the companies can earn on their minerals. The other issue I would like to look at, Ms. Burke could possibly put up page 76, which was the balance sheet from 2022, again up on the screen, and maybe just a little bit bigger so that we can all see it. The company in their liabilities section has senior notes of about $400 million. And I know their presentation talked about that they had $1 billion available to them. Yes, that's very much the case. If they have $1 billion, that is correct. But if you can remember, in 2021, the interest rates were significantly less. They were at 0.08% to borrow money. Now they're at almost 5%, which is 58 times what it cost 2 years ago to borrow money. So if you borrow money, the cost of borrowing money has gone significantly up. And it's those kinds of issues that are important to look at to make sure that an individual company has the capabilities of meeting their obligations that they promise to do with this commission. And I have just looked at some of their issues. This is really, Civitas is a company that has not been in existence for that long. 2021 is when they started to cobble these companies together. If you look at some of the older companies like PDC, they've been around since 1969. So they have a history of being able to save and borrow. Whereas when you have a company that has not been in existence as long, you need to be a little more cautious about what capabilities they have going forward to meet their obligations. And I think because this presentation is recorded, I probably won't go back and talk about mineral, owners getting paid the price that the company gets paid, so that you can actually go back and review this if you choose to on where we are in 2023. This is going to affect the commission as well, because income is going to be down for conservation levies to run the commission come 2023. So it's something that is not just taken out of the air. It is something that can be substantiated and reviewed. I have asked Ms. Burke to look at what the next quarterly SEC filing for Civitas was from their page 6. And if we make it a little bit bigger, we're kind of back to where we were in 2021, whereas their current assets are in the $956 million range, whereas their current liabilities are a little bit over $1 billion. So they're in the position that they were in a couple of years ago, just in that first 3 months. And I think I was trying to show also that April and May are even significantly less financially sound than January through March was. And I think that pretty much summarizes my presentation. My suggestion would just be, we need to look at these types of financial situations to make sure that the obligations that a company puts out there are actually able to be met.
Thank you so much, Ms. Denemy, and the commissioners may have some questions for you, so hold on. I did want to just give a couple sort of summing up remarks. To be clear, we're not suggesting that Civitas is on the brink of insolvency at this moment or anything to that effect. But what we're pointing out is that with market forces and existing debt, that there is a danger of falling behind year over year with the plug-in commitments, with that out of service well list, with the inactive well list. And that if they're not able to keep up the same kind of cadence that Ms. Ryan mentioned, that poses the danger of building up an unworkable backlog of assets that need retirement and reclamation. And so now I think I will turn it back to Mr. Foote. Are we closing up now, or are we going to close up after Civitas's rebuttal? I'm not sure.
I think Civitas gets a rebuttal and then there's closings, but and we don't have anything further. That concludes our presentation in chief, by the way.
Right.
Okay.
So obviously, Mr. Chair, if commissioners have questions, they can do that, whatever your pleasure is for the next steps.
Yeah, I think we're going to do closing by Civitas. Well, actually, rebuttal by Civitas is next, Ms. Ryan. And you do have the opportunity to question any of the witnesses from the petitioners if you so desire.
Thank you, Mr. Chair. Not at this time, but if I have time remaining, I'd like to reserve that, please. And then I will also have a short closing after these rebuttal remarks. If I could get Ms. Shepherd to pull up the slides, we prepared some slides quickly for rebuttal. All right, so I'm going to be jumping around a little bit for talking points. Have about 7 to hit. So thank you for those presentations. I'm going to start with the petitioner's inquiry about option 1. And this was a little interesting to me because it's something I describe as actually surprising and unsurprising all at once. And it was unsurprising that petitioners requested Civitas be required to file an option 1 plan, and that they made this request in their amended petition. So it was something we knew that they were considering. But I say surprising because one would have perhaps expected that petitioners would have manually calculated what that option 1 would look like before requesting it. And if they had, they would have discovered that Civitas would actually provide much less in financial assurance to the state under option 1 as opposed to option 6. And so the company had explored option 1 from time to time before filing its option 6 plan. But when the amended petition came in, I asked Mr. Bennett to create a draft Form 3 that was never filed, but just to see what the option 1 financial assurance would be. And based on the Form 3 that was created on April 26th, Civitas would be required to post a little under $21 million in financial assurance for wells under an option 1 plan. And because Civitas is proposing an option 6 plan, proposing to pay $40 million, almost twice the amount per well. So and then we'll have another slide. This next slide, please. Kind of also shows the math on how this can be possible by comparing Civitas to another large operator who did elect to file an option 1 plan. So for this other operator, they actually have, yes, let's see, almost as many total wells. And it is true that we have almost double the amount of wells covered, but we have over 6 times the amount of financial assurance that's proposed. So over 6 times for less than double. So I think, it can't really be reasonably disputed that what we're proposing protects Colorado. The second point I'd like to make is that Civitas maintains that its asset retirement plan and active well lists are sufficient and are detailed under the rules. They're comparable to what other operators have filed and you've approved, and in certain ways, they're more robust. The asset retirement plan and an active well list meet the face of the rule criteria and also the guidance we have from the FBP, which explains that when the director is reviewing an asset retirement plan, it will examine the operator's reasons for maintaining inactive wells and the timing of the operator's plan to retire assets. And the commission has created guidance on the asset retirement plan, and it has not added anything to this other than the SBP language. Creating a higher standard just for Civitas, in our view, would be arbitrary and capricious under the Administrative Procedure Act because other operators' plans were comparable or less robust. And when I say less robust in certain circumstances, I'm certainly not criticizing other operators' plans that have been approved. I think they were also appropriate, but the point is that Civitas's plans are as detailed as they reasonably can be. Field conditions change, acreage position changes, technologies change. What Civitas did is it exhaustively explained its methodology and then some degree of flexibility in the implementation of the asset retirement plan is reasonable and necessary to reflect real world conditions. And I'm going to go to a slide in a moment that shows the inactive well list reasons just compared to another recently approved option 6 operator. But before doing that, I just want to kind of re-anchor the conversation about the purpose of the rules overall, which is that the rules were designed to make sure sufficient financial assurance exists. So the operator demonstrates that it has enough financial assurance to comply with the rules and the act. And I appreciate that local governments are interested in planning, but the financial assurance rules were not designed as a planning tool for local governments. Wells at issue in an active well list or an asset retirement plan are pre-existing land uses that local governments have always had to consider, and precise timelines are not always possible for the reasons Mr. Bennett can explain if you'd like. But now if we could just quickly visit slide 4, please. So this is just sort of a quick little contrast to Mr. Frank's position that other operators had more robust wells reasons for their wells and activity. These are just 2 of the reasons, the only 2 that were listed in a recently approved operator option 6 plan. I just think it is a helpful demonstrative to show that it can't seriously be said that Civitas's reasoning lags behind what the approved operator provided. Also, in response to Mr. Foote, his comments about why 6 wells in Broomfield are not on the out of service list, I want to point out that no rule requires an operator to explain why a well is not on an out of service list. And you can think about what a heavy lift this rule would be and why it makes sense that it's not in the rules. Because in the instance of Civitas, for example, that has over 3,000 wells subject to financial assurance and over 4,000 wells overall, it would have to explain for over 3,000 wells why they are not on an inactive well, or excuse me, not on an out of service list. All the rules require is that an operator explains why a well is on an inactive well list, which it does. You don't have to prove in the negative, and you don't have to provide this for out of service list at all. So what Civitas did in its asset retirement plan, and described by Mr. Bennett's earlier remarks, is it explained its criteria for out of service wells. And the wells in Broomfield mentioned by Mr. Foote do not meet the eligibility criteria. And so that's why they're not on the out of service well list, whereas the ones that are on the out of service well list did meet that criteria. But getting sort of back to the core purpose of today's hearing, this issue really is sort of a red herring, because at issue is whether Civitas's plan complies with the rules and demonstrates Civitas has the financial wherewithal to comply with the act and the rules. And just like with the other items in the active well list, it's conspicuous to me that Mr. Foote didn't refer to a rule when criticizing Civitas for not explaining why these wells are not on an out of service list. But that's because there's no rule to cite to. Broomfield and Civitas might have a separate conversation about these wells, but that conversation is not relevant to what's at issue today, which is whether the proposed financial assurance is sufficient. I also want to put the remarks about out of service wells and inactive wells in perspective to the big picture. So if you could please go to slides 12 and 13, Ms. Shepard. Okay, so first, this is just the inactive well list. So there's 13 inactive wells in Boulder County, 2 inactive wells in the city of County in Broomfield, and 6 inactive wells in Erie, 2 of which are also in Boulder County. So it's a double count in that sense. But the rest of the inactive wells, the vast majority of Civitas's inactive wells aren't in petitioner's jurisdictions. We'll go to the following slide, please. And this similarly shows how these wells compare on an out of service basis. A lot of the out of service wells, the sufficiency of the information was contested, but it's clear that it's a very slim minority of Civitas's overall portfolio that these things even speak to. And again, we understand that petitioners may want more information, but the financial assurance rules do not require more detail than what Civitas provided. And the degree of information that would be required was certainly fully ventilated during the rulemaking hearing itself. Fourth, there were some comments about, well, what happens? How do we have some insurance that Civitas can continue meeting its obligations? It was never asserted by any petitioner that Civitas has never not met any obligations. And one of the mechanisms that you'll know this beyond, as Director Murphy spoke to earlier in another docket, the annual review, and here, because we're in option 6, we'd have a annual review, or excuse me, a hearing every 3 years on top of that annual review. But also in terms of making progress on its plugging list specifically, we have the Form 6B. This must be submitted annually, and also the director must review it annually. The form, when submitted, explains an operator's progress and identifies wells on the out of service list that have not been plugged that are located within 2,000 feet of sensitive receptors or are located in high priority habitat. When the director reviews this as required by rule, the director has to determine whether the operator is financially and operationally capable of plugging and abandoning the wells on its list within the required timeframes. Not only that, but the director doesn't look just at, are the wells actually plugged? the director is also empowered to look at whether the operator is making substantial progress, piecemeal progress as the years progress on its list. And if the operator is not doing so, among other things, the rules allow the director to request additional financial assurance. Finally, I want to speak to overall financial health. And what Mrs. Denomi did not say was as telling to me as what she did say. I did not hear her say that Civitas would not be able to meet its obligations in the future. Instead, she speculated if Civitas would be able to continue meeting its obligations in the future. She shared a spreadsheet trying to cast doubt about the company's future revenues, but I'd like to point out that that spreadsheet only covered a few of the wells of the companies, which it has over 3,000 wells not on out of service plugging lists. And also it showed price changes over a few years. It's not news that oil and gas prices rise and fall. And Mrs. Denomi herself noted that this issue is not specific to Civitas, but applies throughout the industry. It's also not news that interest rates rise and fall. These realities are built into all of the company's decision-making. And Mr. Boekmeyer will now speak more to Civitas's strong financial position and how it considers market forces. I think if you could drive to slide 7 to get us started, please. I'll now turn it over to Mr. Boekmeyer and Ms. Almas as well, if she would like to add anything.
Thanks, Julia, and thanks, commissioners, for hearing this rebuttal. I guess we can start with the balance sheet, as Ms. Denomi spent much of her time there drawing comparison between our current assets and current liabilities and trying to paint a picture of financial insolvency as a result of that. At the same time, the focus of it, I think they concluded in their presentation that there's no doubt as to Civitas' financial ability to operate into the near term. So comparing current assets and current liabilities doesn't really get to long-term concerns. That being said, our current ratio is very strong, and it does not indicate an inability to pay current expenses as they come due. We continue to do that, and we will continue to do that. And then just on the topic of, just one other thing to highlight with current liabilities and what that analysis lacks is the current liabilities are by definition meant to be paid over a period of a 12-month period. Many of them aren't due and payable currently. Some of them, are paid upon the receipt of revenues, so paid with funds that we receive in, and don't indicate an inability to pay, based on what we have at year end. In terms of, let's see, and then further, that analysis also neglects to consider the fact that we have $1 billion of undrawn availability on our credit facility that would further supplement the company's cash on hand should it be needed. That being said, it hasn't been needed since the formation of Civitas, and it continues to be undrawn to date and as of year end. And the company continues to generate more than sufficient cash flows from its operations to cover all of its liabilities and obligations as they come due. In fact, to that point, we have, as a company, filed our Q1 2023 Form 10Q with the SEC relatively recently, and in Q1, just to highlight the fact that the company continues to operate. We generated over $500 million of cash flows from operations, and that's on top of all cash requirements necessary and used in the course of our normal course of business, including the settlement of asset retirement obligations. I would say then, just moving. Just to round out that point, we have presented on this slide a comparison of Civitas to other peer companies that have completed and have approved option 6 financial filings. And you can see that in the ratio of current assets to current liabilities, Civitas compares favorably to both of those peers. I think that's all I'd like to cover on the balance sheet, and then maybe we can just kind of pivot to the impact of commodity price volatility on our business. Commodity price volatility in oil and gas, or really any commodity market or commodity-based business, is not a novel concept, as Julia mentioned. And it's something that we plan for in every aspect of our business and our decisions that we make. Certainly not unique to Civitas, and our financial strength, as we've highlighted in our balance sheet and our available liquidity position, our ability to generate cash flows as a company, position us favorably to withstand decreases in commodity prices into the future. It's no secret that commodity prices do have an effect on the bottom line, but with how we've managed our business and the way we mitigate commodity prices in our decision making through the strength of our balance sheet is highlighted in the liquidity that we have, the capital efficient asset base that we strive to have, our cost leadership and a cost structure, and our relentless focus on maintaining an efficient cost profile minimizes the risk of a commodity downside and allows us to continue to generate cash flows in excess of what's required for our operations well into the future. I don't know. Yeah, and then just to highlight the topic that Julia had brought up as the exhibit that Ms. Denemy presented of gas price volatility over the past 2 years on a couple of wells in Boulder County. I would echo that is not representative of the impact of commodity prices to the company at large. Obviously, we operate thousands of wells, and furthermore, gas as a source of revenue is a relatively minor part of our business and constitutes, even in 2022 when prices did spike, as Ms. Denemy pointed out, following Russia's invasion of Ukraine, they constituted only 18% of our company's revenues in 2022. And with that, I think that's all I had to rebut. I don't know, Vanessa, if you had anything else that you thought would be helpful to discuss.
I think we're all set, but she'll be available to answer questions. Thank you very much, Mr. Bookmeyer. That was very helpful, I hope. And that concludes our rebuttal. Thank you.
All right. With that, I believe that the next step is closing presentation by petitioners, followed by closing by Civitas, and then commissioner questions.
All right, thank you very much, Mr. Chair. And thank you again, commissioners, for hearing this and giving our positions your consideration. At the beginning of this proceeding, you heard Civitas claim that the local governments really just disagreed with the rules, and that must be why we were petitioning. But on the contrary, we just want Civitas to follow the rules. They have filed the required forms and checked some boxes, but at this point, they should really be getting an incomplete grade. Just first to clarify the option 1 request, you'll recall my request during the opening statement was for the commission to consider option 1 if that was more protective of the state and of local governments. This is another example of the company having access to information that local governments have to use our best guess to assess. We can't calculate what Civitas would owe under a certain option, but the request, as you recall, was to consider it. But at this point, I want to emphasize three plus a subpart requests to the commission. And none of those should be a surprise to Civitas because we've been asking for these things from them for quite some time. First, regarding its out of service well list, Civitas provided no reason why some but not all of the spudded but not completed wells at the same locations in Broomfield are not on its out of service list. They seem to have a reason, but they are withholding that information. It makes Broomfield nervous when Civitas withholds information, and it should make the commission nervous too. It's relevant to the accuracy and details of their financial assurance filing, and it isn't unreasonable to provide more information to the local government and the commission. The rules clearly contemplate for the commissioners to ask for more information. And to be clear, again, we're not asking for information related to 4,000 wells all across the state and other jurisdictions. We're asking for information related to 6 wells in Broomfield. That is not an onerous request. Second, regarding its inactive well list, as David Frank's testimony demonstrated, there's no legitimate reason why Civitas can't be more specific about why each of their wells are inactive and provide a good faith estimate about when each of those inactive wells will either be plugged or returned to production. That is just basic transparency. And Rule 702E2F Roman 1 allows the commission to require, quote, specific dates by which the operator will plug and abandon certain wells. We think the commission sought to encourage transparency in these filings and not a race to the bottom to see how little a company could disclose and get away with it. Civitas should be required to submit a new inactive well list in order to comply with the rules. Third, regarding future disclosures, Civitas should have to submit progress reports on its plugging of inactive and out of service wells, including what they plugged in the past year and what they're planning to plug in the upcoming year. You all have been requiring some form of progress reports in your prior option 6 hearings, as well as the own resources hearing that just concluded. COGCC agreed to provide such reports at the May 3rd hearing on its financial assurance application, which shows that such a requirement is not burdensome. Rule 702E2F Roman 2 specifically grants this commission the authority to require periodic progress reports for this purpose. And Mr. Bennett testified earlier that every well is reviewed on a quarterly basis. Therefore, again, it should not be onerous for Civitas to provide such progress reports to verify its ongoing commitment to meeting its asset retirement plan and other requirements of the rules. And along with examining that progress, the director and staff should be specifically tasked to take a very close look at the Civitas financial statements at each annual review, not assume just because Civitas was in a strong position in 2022, that it will be that way in each following year. Of course, the progress reports and financial review will only be meaningful if any changes or concerns found with them lead to adjustments in the financial assurance package. And tied to future disclosures, this would be like request 3A, a request we made of Civitas before, and you heard Mr. Frank talk about in his presentation, is that they should submit their Form 6, 6A, 6B, and 5B reports the relevant local governments have asked. It is very difficult to know by going through the COGCC database whether Civitas has actually submitted those forms or has not submitted those forms. We had to specifically ask for some of those forms in the pre-hearing process because we just couldn't get to them. None of these requests are at all unreasonable. They are all relevant to the Civitas financial assurance application. The commission has the authority to require that information under the rules I already mentioned, as well as the general rule of 702E2E. And they are all within the spirit of the rules as well, which are designed or were designed to encourage transparency and accountability to the state and to affected local governments. So again, we really appreciate your consideration and hope you will seriously consider these 3 and 3A requests that we made as part of the financial assurance application that Civitas submitted. Thank you.
All right. Thank you, Mr. Foote, and thank you for the closing. I believe at this point, we now have a closing presentation by Civitas followed by Q&A.
Thank you, Chair. Civitas agrees with the director's recommendation that Civitas meets all the rule criteria necessary to obtain its option 6 plan approval. The heightened standards and these additional requirements that petitioners urge have no basis in the rules. The local governments ask for many things that the rules do not require and that you have not required of other option 6 operators, with the exception being, the one exception being providing a narrative on an operator's plugging progress, which I understand one of your 2 approved option 6 operators agreed to provide, and which Civitas will also agree to do. Civitas's balance sheets are strong. Its financial discipline has been demonstrated to you in several ways, including that Civitas has low levels of debt and is the lowest cost operator among its peers. Civitas intends to keep its financial position strong, and it's well poised to do so. Should Civitas's financial condition change, the rules provide substantial oversight for you to revisit the option 6 plan. You heard a bit about these earlier, but since that was in a different docket being recorded separately, I'll just remind you that under Rule 707B, the director reviews financial assurance plans annually. As well, under Rule 702C6 and 707B1, Civitas's specific financial assurance plan will come before you for regular review every 3 years, and that is at a hearing. Moreover, under Rule 707B2, the Commission at any time may commence a financial assurance hearing as to any operator on their own motion. And there's also the annual Form 6B review that the director is required to do that I mentioned in rebuttal. So the rules themselves, there's already a system of checks and balances implemented in just the architecture of your rules. And this allows you to see an operator's financial wherewithal more closely than you've ever been equipped before. Neither Civitas nor any of the entities comprising the company before they were part of Civitas have ever not satisfied their obligations to plug and abandon their wells at the end of their lives. We disagree with petitioners about whether this is rule implementation or otherwise, but it still appears to us that that their concerns challenge more the rules writ large than challenges to Civitas's specific information. And there has not been, in fact, that I've been listening to, even a direct allegation that Civitas does not have the financial resources to comply with the rules and act, which I find significant. These concerns do not suggest the Commission should deny option 6 for Civitas. And I'll just remind you that this is the largest bond the Commission has considered, actually. And even though Civitas does not have the highest number of total wells that you've considered, it would still be providing this max $40 million bond. We welcome questions and thank you very much for your attention this afternoon.
Okay, thank you very much for the closing. I believe we now have finalized the introduction of evidence and testimony with regard to the Civitas financial assurance proposal. And just to put a fine tooth on it, Ms. Ryan, so you agreed with the third request made by the petitioners with regard to future disclosures with regard on plugging, is that right?
Yes, and an annual submission to the Commission that summarizes the progress on the out of service plug-in list, like the other option 6 operator agreed to. We're welcome to voluntarily, we will voluntarily take that on.
Okay, thank you. All right, commissioners, at this time, it is an opportunity for questions from commissioners to both the applicant as well as petitioners. I would wonder if maybe we try to start first with the applicant and then go to petitioners, but I'm not going to put constraints in terms of how we do that. So who has questions for either the applicant or petitioners? Commissioner Cross?
Thank you, Mr. Chair. I'd like to delve into a little bit, and this probably is going to go to Mr. Bennett, to go into a little bit on the discussion of the commerciality and midstream. Am I right in assuming that they're currently out of service because they're not hooked up to midstream that will pull the product away from the well site? Is that correct?
Thank you for your question, Commissioner Cross. Point of clarification, the commerciality midstream component that's been discussed by the protestants is associated with our inactive well list, not the out of service well list.
Okay.
To that end, that is not necessarily the case. Specifically, there may be instances where a well is in fact inactive that may have a connection to a midstream system. I will go on to say that there's a pseudo symbiotic relationship between commerciality and midstream as used in this context. In general, the commerciality of a well can be defined as a well's ability to generate revenue greater than the expense incurred to produce that well. There are several factors that are considered when assessing the commerciality of a well. These include, but are certainly not limited to, the well's production rate and volume, the processes required to not only run the well, but also ensure the natural gas produced is of saleable quality, and the ability to produce into a pipeline. It's important to note that the ability to produce in a pipeline is not as simple as tapping into a gathering system and producing the well. That is, the characteristics of a well's production stream need to be compatible with the operating specifications of that pipeline system. Perhaps the biggest challenge in meeting these requirements is pressure. Simply stated, a low pressure well cannot produce into a higher pressure pipeline without compression or other post-production operations. So to your earlier point, we may have pipeline connections in some instances, but the well is unable to produce into that pipeline because it cannot reach the pressures necessary to do so. That said, the need for these secondary processes increase the cost incurred to move a cubic foot of natural gas from the wellhead into the pipeline and downstream to market. Thus, when expenses are greater than revenue, a well is often deemed to lack commerciality. In situations where a natural gas pipeline does not exist, similar considerations apply. For example, the estimated revenue that a well could generate point forward is compared with the capital required to construct a new pipeline that would connect the well to an existing natural gas pipeline system and thereby allow the well to produce. If the expense to permit and construct a new pipeline outweighs that of the estimated revenue, the commerciality of this project is again lacking. This type of example often occurs when natural gas pipeline systems are taken out of service or shut in for long-term maintenance or repair. And I bring those points up because I think over the last several months, there's been a number of matters that have focused on the availability of pipeline systems to accommodate low pressure or low producing wells. So I appreciate the opportunity to address your question.
And so I think to put a clarifying point on this, so a lot of the inactives, and I apologize for saying the out of service before, a lot of the inactive wells that we're talking about are situations where they may still be profitable at a different price point, but at this current time, let's say, just to put even numbers on it, it costs your price you're going to get is $1, but installing a pump jack, installing some kind of other equipment that's going to get the natural gas and the oil into the pipeline that's going to be at a saleable rate might be $1.10. And so at that point in time, it's not commercial to spend the money if you're only getting $1 back. Is that correct?
Yes, that's a very fair statement.
Okay. And so in those situations, do you have, and I'm trying to, I'll just say I'm trying to build a little bit of a bridge here between some of the questions that are being raised by petitioners and what's coming forward here. Do you have an idea on some of those of when they will be brought back into service or maybe brought back into service, or are those in such a condition where it's likely they're not going to come back into service?
Again, thank you for the question, Commissioner, and it's a very good one. You know, as has been stated repeatedly, you know, we have used a consistent date in most instances on our inactive well report, if you will. That date, you know, and quite frankly, was December 1st of this year, which in fact was chosen as an initial target and ties directly to our well review process that I've discussed elsewhere in my testimony. That is, every well on the inactive well list will have been analyzed no fewer than 4 times since the initial filing by the date referenced within that filing. This timeframe does afford our team the opportunity to make prudent decisions on a well's future, given the likelihood that something has changed. For example, the ability to access midstream infrastructure, changes in commodity price, to your point, accelerated offset development, and so on. It should be noted that the analysis could also result in a decision to take no action, thereby allowing the well to remain inactive in accordance with the various rules and regulations governing such status. More importantly, the inactive well list and supporting details, as you've heard from Ms. Ryan and others, are filed annually, thereby providing an opportunity to update that information, including the anticipated or planned date when a well may be plugged to return to production, again, based on the most recent assessments. And so rather than speculate as to, you know, this well could come on October 1st of 2023, or this well could come on, July 5th of 2024. We thought it prudent to be consistent in that planned date, knowing how many times those 102 wells were going to be reviewed by our various teams, and really update that with our annual filings to ensure we have the most accurate information. In the screenshot that Mr. Frank showed during his presentation, there were at least 2 wells that had planned plugging dates in the right-hand column that were showcased in that screenshot. And so we do know, based on our schedule, that at least 2 of the 102 inactive wells will be plugged before year end of this year.
Okay, and I appreciate that clarification. And when it comes to the financial aspect of Civitas's current position, I just want to try and get an understanding. One, clarify that the numbers that were presented by Ms. Denemy were again related to natural gas only, not the oil and gas, which was a little bit more volatile in the last year than the gas price, or than the oil prices, excuse me. But 2, that to try and just put a finer point on why that volatility that's being discussed is not really a concern to Civitas.
Thanks for your question, Commissioner Cross. I think as we tried to highlight in our rebuttal slide, our business is planned with volatility in mind. And I think the volatility observed in 2022 is mostly upside volatility relating to macroeconomic factors such as Russia's invasion of Ukraine, and certainly not something that we've planned our business based upon. We didn't expect oil to go to $130 a barrel following that. Since things have normalized in the commodity price market and largely kind of come back down to recent averages in 2023, we continue to experience extremely high profitability and cash flows as a function of the structure of our business. We have a relentless focus on cost and planning. So making sure that we're being efficient with our capital spend. We plan our wells at prices far below current market prices, and develop long laterals that are capable of generating high internal rates of return. And furthermore, we also have a relentless focus on costs. So trying to keep operating costs as low as possible, while still being a prudent operator and meeting all, regulatory requirements. So, as demonstrated in, as mentioned by Ms. Ryan, our cost structure is among the lowest among our peers, and therefore, as prices decrease, we still have plenty of margin to generate cash flows from operations that are in excess of what's required to maintain our just ongoing operations, including asset retirement obligations.
And to go into a little bit more detail, so looking at the 10Q that Ms. Denemy talked about, in your rebuttal, you were talking about, and I believe it was the year-end numbers based on the 1.13 assets compared to liabilities. So when you're looking at the current assets versus the current liabilities, you were saying a ratio of a little bit more than 1. So more assets than liabilities at year end.
Yep.
And that's even taking into account the long-term obligations for asset retirement, correct?
That is not correct. So current assets versus current liabilities is really a measure of a short-term liquidity. So it's cash on hand and then other assets that we expect to receive in the next 12 months compared with liabilities over that same time. They may or may not be currently in hand. They have different degrees of liquidity, and the liabilities, some of which are to be scheduled to be paid up to a year from the date of the balance sheet presented. The ratio of current assets and current liabilities is something that's relevant in assessing a company's financial health, particularly its short-term liquidity. But I'll also point out that that in addition to the cash and cash equivalents that is included within our total current assets, we also have an undrawn credit facility that affords us an additional $1 billion of liquidity should it be needed. And that hasn't been needed in 2023 and was not needed in 2022 either. So when that is factored in, current assets far exceeds current liability. And furthermore, this is something that's contemplated by our lenders in our covenants associated with our revolving credit facility. There is a current ratio stipulation that also kind of includes a similar calculation that we would apply undrawn credit facility borrowing base capacity to current assets when evaluating the ratio of that to current liabilities.
And I apologize for that. I may have miswritten something.
Current liabilities does include short-term, like current asset retirement obligations that we expect to undertake within 12 months from the balance sheet. So you'll see $25 million on our balance sheet in current liabilities.
But in the rebuttal slide that you showed, was the ratio that you were showing the current, or was that the long term? And I apologize, I had written
they were both presented there. That was something that we had prepared in advance. So I think it also did show current liabilities to total liabilities, which we believe to be less relevant. But in the far right hand section of that table, you can see how Civitas compares to our peers that have also had approved financial option 6 financial assurance plans in the ratio of current assets to current liabilities, and we compare very favorably in those comparisons.
And I appreciate that. And again, to know one of the parts of your answer there as well, the asset retirement, such as plugging and abandoning and reclamation, is already accounted for in that balance sheet, correct?
That's correct. Yes, that's correct. And it's shown in 2 places in short term. So that's very much aligned with our budgeting process. That's the 25 million you see in current liabilities. And then the long-term portion, which was everything to be undertaken after 1 year.
Perfect. And you also touched upon the revolver that you have with respect to the credit facility there. Is that amount, and this goes again back to some of the testimony that Ms. Dinamy gave, is that set on a fixed interest rate, or is that set on a variable interest rate depending on where the markets currently are?
There's various options within the credit agreement depending on the tenure and the length of the borrowings we wish to draw from the credit facility. But yes, to answer your question, they are variable in nature. They're based on a SOFR rate, so similar to kind of a LIBOR rate that changes based upon how long we intend to borrow it and things of that nature. So yes, certainly increases in interest rate increase the cost of borrowing. Okay. That's not unique to Civitas.
Understood.
Yeah.
And then I want to trying to think if it's because I know Mr. Bennett, you did touch briefly on some of the presentation provided by Mr. Frank. But if you could go into a little bit more detail to talk about to what extent you have, you mentioned the 2 wells that you already have on the plugging schedule in the area there, but do you have any kind of plan? Have you had discussions with the town of Erie about some of these sites where he mentioned during his testimony that there was questions about potential development, there's questions about potential building, et cetera, and use of parks and things like that. Have you had those conversations with the town of Erie? And do you have an idea on some of those, aside from the 2 that you mentioned that were in the presentation that are on the plugging schedule? Do you have any kind of immediate plans for those?
Thank you, Commissioner Cross, for your question, and I'll do my best to answer it. Specifically, the wells that Mr. Frank showed on his slide or during his presentation, to the best of my knowledge, we have not specifically talked about those 5 wells or the other 2 that were shown. But for these proceedings, our recent conversations with the town of Erie have really focused on new drill development and wells that could potentially offset other wells within the town's boundaries and what that could look like if that development did occur. But again, to your specific question, we have not had in-depth detailed discussions about the handful of wells on the inactive list or those on the out-of-service list that may reside within the town's boundaries.
And when you do have any kind of questions about the offset, does Mr. Frank or other LGDs, not necessarily with respect to Erie, do they often talk about preferences for what be plugged first based on planning moving forward?
Certainly, again, thanks for the question. You know, as you are probably aware, it's a series of conversations when we engage local governments about future potential development, offsetting existing wells and what that could look like. I did mention, I think, or at least it was contained in some of our materials, that there are contractual obligations that inform a well's future as well. And so the ability to maintain certain contracts until such a time that you have producing inventory and offset acreage is part of that conversation. And in those instances with governments where we've been successful, we've certainly made commitments to plug and abandon existing wells after the initiation of new production from that general vicinity.
And if I can maybe ask some questions, I'll start with Ms. Denemy. I think that one of the questions that I wanted to focus on went to Ms. Ryan's closing statement there. And you spent some time going through some of the volatility and the gas prices. You spent some time talking about the balance sheets and some of the royalties that have been received with some of your clients. But one of the things Ms. Ryan tried to say is there's not an argument that Civitas will not have an ability to pay. Would you agree with that statement?
I did not state that that's the case. Civitas will be in the same position as many of the other companies that are in existence in Colorado, and they will need to determine how to cut costs if the income is less. So I was not suggesting that they're going to be in a financial problem, but they're not going to have as much money coming in. So all of us, when money is not less, we all have to make some budget decisions to do. So my suggestion was more that just to look at a snapshot for what happened at the end of 2022 isn't sufficient to say that that's what's going to happen by the end of this year, and that it should continue with the rules that financial assurance should be looked at annually so that the obligations can be met based on what their income is for that year.
So part of the argument is to make sure that we have these annual updates to make sure that they're kind of keeping on track with what was proposed.
Precisely.
Okay. That makes the remainder of the questions I have kind of moot, I guess I'll say, so I appreciate that. And then I think that's the questions I have for right now. I appreciate it. Thank you.
Further questions from commissioners to the panel? Commissioner McGowan?
Thank you, Mr. Chair, and thank you for everyone for their information and presentations today. If I could go back to, I'm trying to make sure that I was paying enough attention and understood Commissioner Cross's questions about the local governments that are curious about the inactive wells within their jurisdictions and don't feel like they understand why their status might not be out of service and or what the schedule might be for them. Are you saying that Erie actually has never asked Civitas about the wells that they showed us today? Is that what you said?
Thank you, Commissioner McGowan, for your question, and I'll encourage Mr. Frank to chime in if he feels differently. As I attempted to highlight for Commissioner Cross, we have had discussions with the town of Erie about various things within the municipality, including our existing well portfolio and what the potential for that portfolio may be if we're able to develop, acreage in or around that jurisdiction horizontally, right? And so most of the wells within the town of Erie are vertical or directional wells. But to the best of my knowledge, the 5 wells that Mr. Frank showcased in his presentation this morning, we have not specifically talked about. Again, if I'm remiss, I encourage Mr. Frank to correct me, but that's my recollection.
Yeah, Mr. Bennett's correct. We haven't inquired about those wells specifically, and those wells were just exemplary of consistent conditions across, especially the southwestern portion of Erie. And as Mr. Bennett said, there have certainly been discussions about the status of low producing or out of service or inactive wells generally, though not specifically. And also, as he characterized, when the town is asked, when maybe can some of these wells be plugged? The answer has consistently been when the town approves new drilling. And so we sort of feel like these wells are I don't want to say used to hold. I don't want to speak out of line, but the viability of a well and whether or not it is in the interests of the residents of Colorado to be in existence shouldn't be dependent on whether or not local governments approve new drilling developments.
Thank you. So likewise, it does sound to me like there have been conversations with Broomfield and the wells that they have questions about. Is that correct?
I appreciate, again, your question, Commissioner McGowan. It's a very similar circumstance with City and County of Broomfield that I explained with the town of Erie. We've had discussions relative to Civi's existing portfolio within the city and county, that those wells are operated by one of 2 operating companies, Extraction Oil and Gas, as you heard Mr. Foote refer to earlier, as well as Crestone Peak Resources. It's been some time since we've had any questions related to the 6 wells, I think it was, that Mr. Foote showcased. I will reiterate our position that, there is no rule requiring an operator to designate a well as out of service. We believe those wells are compliant, and we want to preserve the ability to return to those wells in accordance with COGCC rules and regulations at some point in time in the future, should we choose to do so.
Okay, thank you. So I will
Mr.
just
McGowan?
ask this. Yes.
I apologize. I wanted to add about your question, which is that Broomfield has specifically asked about those 6 wells 3 different times during the course of these pre-hearing proceedings. And we've not received any response from Civitas about those wells at all, which is why we're bringing it up here.
Thank you. So as an aside, and hopefully the operator is recognizing that maybe people are frustrated and trying to figure out some sort of avenue to get communications from an operator, and they're taking this opportunity because it's available and they have standing through the financial assurance. So, I would encourage the operator to think about what it means to be a good neighbor and have communications with local governments who are affected by the operations you have within their boundaries, and try to be more transparent about what it is that you are doing or not doing and why. That aside, I do agree with the folks who are testifying from the local government perspective that in one of the other financial assurance rulemakings where the operator submitted the same exact date for all of their out of service wells and the inactive wells were less of a focus for the commission, it was frustrating for me as a commissioner to see the same date for everything and then wonder if we were going to get to that date and things were not actually going to happen in the way that they were supposed to occur, and not wait until the last date to say, this is when I'm going to plug all my wells that are on the out of service list, because we have that 6-year time frame within which to do that. And so I definitely am interested in having a conversation about checking in on the out of service wells and their status, and making sure that we're not waiting till the 6th year to do everything that's required as part of that incentive that we're giving for wells on the out of service list. And I guess in this case, I would also like regular check-ins about the inactive wells and their status, because there's a convenient 6-month date that the operator has chosen here, because inactive wells have to have some sort of decision within 6 months. And I would be curious to know their status also on a regular basis, to make sure that there's something happening with those and there is transparency and some communication around it. And I guess there's no question there other than I'm going to be, I think, asking for something along those lines to my fellow commissioners.
Others with questions? Commissioner Ackerman?
Thanks, Mr. Chair. I just have a couple of questions, but I wanted to first state that I agree with Commissioner McGowan's comment that the communications with entities regarding the plugging of wells is related to, but certainly very different from the question of whether or not Civitas has met the requirements of a financial assurance hearing. That said, communication with the affected local governments is paramount to the industry working properly in the state of Colorado. And so I did want to take this opportunity to ask Civitas, and Mr. Bennett, these are likely for you, a couple of questions. The first question is regarding the assertion that's been repeated a few times here today, that the local governments are having a difficult time getting the information that they want or that they need from Civitas. And I just wanted to see if you could address that a little further. What does Civitas feel is appropriate cooperation and collaboration with local governments, and what does Civitas do to attempt to collaborate with the affected local jurisdictions?
I appreciate the question, Commissioner Ackerman, and I hope I do your question justice with my response. As we've indicated, we oftentimes communicate frequently with local governments over certain topics, specifically those related to ongoing and active development. Mr. Foote, clearly indicated that they had asked roughly 3 times during these proceedings leading up to this hearing for additional information on those 6 wells in Broomfield. I did mention in my comments that it had been some time since we had been asked about those wells, and that actually refers to being asked about those wells outside the context of the financial assurances hearing, and more importantly, dealing directly with staff. And so City and County of Broomfield staff, along with Civitas staff, do communicate routinely. Those questions about those wells were asked after the initial posting of the out-of-service plugging list last fall. We discussed it briefly at that time. I don't recall, but I assume there wasn't a lot of granular information provided to them then, but wanted to clarify the record in that regard. We are always willing to talk with and work with local governments. As it relates to financial assurance, it's my opinion, and I may not speak for anyone else, but whether or not those wells are on the out of service list is immaterial. I think we've demonstrated our obligations under the 700 series rules and everything associated therewith relative to the plan. That said, we also believe those wells are compliant with COGCC regulation, and therefore we do have the ability to revisit those wells at a later date should we choose to do so. Going forward, if City and County of Broomfield, Town of Erie, County of Boulder would like to continue meaningful discussions related to these topics, we are certainly willing to do so, and obviously prefer to do it in a more informal manner than perhaps at a hearing before the commission.
Thank you, Mr. Bennett, and I'm not disputing the facts that you raised, that I believe that the burden has been met on other fronts. I have one more question for you, but first would like to ask Mr. Foote, if you wouldn't mind, a similar question, if we still have Mr. Foote with us.
I'm here.
Oh, great. Thank you, Mr. Foote. This seems to be the rub, as Commissioner McGowan brought up, and really what's precipitated the petition here today, from what I can read. What is it that specifically, can you recap for us a little bit specifically what the petitioning parties really would need and like to have with regard to communication from Civitas going forward?
Yes, thank you, Commissioner Ackerman. So the petitioning parties initially petitioned because there were a lot of questions about the Form 3s and the other documents that were submitted. And through the pre-hearing process, some of those questions were answered. There was revised documents filed. And so it's been somewhat of an iterative process, but a number remain, which is why we brought them up here. I'll go back to my 3 asks. Well, it's really kind of 3 And then the subpart ask as well that I did in closing, if that's what you're asking about. Those are the things that we still feel like need to be answered. Actually, one of them already was answered because Civitas has now agreed to the annual reporting, which they hadn't agreed to before. So we can strike that off the list. But regarding the inactive well list, the ask is for more specificity there. Commercial midstream is not compliant with the rules. It also, of course, doesn't give any information to the commission or the local governments. And the dates that are on the inactive well list right now are, again, insufficient for according to the rules, as well as any kind of real information to local governments. Almost all of them are listed as December 1st of 2023, which is well beyond the 6 months actually when it was submitted. That's required under 434. Regarding the out of service list, it does go back to the 6 wells that Broomfield is specifically interested in, and Broomfield has seen no discernible reason why those would not be on the out of service list. And really clearly it's something that would be pretty easy information for Broomfield to disclose or change their out of service list if that was appropriate. And then regarding the financial part, I see that Kate Burke has highlighted or shown herself here, so she might want to chime in on that, and that's been her witness, so I think I'll defer to her on those particular elements.
Oh, well, thanks, Mr. Foote. I was actually going to kind of add a different gloss over all of our requests, but the theme of our requests is more transparency as intended by the rules. But I also want to point out that even though Mr. Foote and Mr. Frank referred to specific wells in their jurisdictions about which they may have questions, I think in many cases those were used as illustrations of concerns that we have about the application and the plan that affect the plan statewide. And so while it has come to light that there are some communication issues that we would love to get fixed. At the same time, I do want to point out those are not our only concerns. I'll speak for Boulder County on this, but we are also the financial issue concerns, the inactive well list, reasons for low production, the asset retirement plans, sparsity. These are things that we feel like are not true to the spirit of the rules for any plan statewide, and the fact that we are local governments with certain jurisdictions, our concerns come from experience within them, but they're also broader than that. So I guess that was kind of the main point I wanted to make. With respect to the financial issues, again, our request is simply that staff be tasked to take a truly deep dive into those financial documents at the annual review. The annual review already exists, it's set up, it happens. I don't know, I'm not sure if staff knows yet what exactly they'll be doing at those annual reviews, but I know that at the May 3rd hearing on other option 6 plans, there was some direction given for staff to take a careful look at, I believe it was the progress on plugging commitments. And so we're just asking for another similar specific to-do item for staff that they really need to take a careful look at financials and see if they are looking promising for keeping up with those annual plugging obligations.
Thank you, Ms. Burke, and thank you, Mr. Foote, for those responses. I realized that I was asking for some degree of repetition there, and appreciate you going back and being specific in your thoughts. I appreciate that very much. Mr. Chair, if I might, I do have one more question for Mr. Bennett. Mr. Bennett, a point was raised during testimony here that certainly would cause me concern if it were to be true. Can you talk a little bit about whether or not Civitas takes into account whether a local jurisdiction allows permitting of new wells prior to its determination of whether it will P&A&R an existing well? And if appropriate, can you share any examples of upcoming P&A plans that are within the jurisdictions of the petitioners?
Thank you, Commissioner Ackerman, for your question. I think I heard 2 different elements in there. One was a request for a response to coordination with local governments as it relates to new development within their jurisdiction. And then 2, do I have any plans, or do we have any plans certain for plugging, abandonment, and reclamation in any of the jurisdictions represented here today? Is that correct?
Yeah, and specifically, do you take into account whether or not a local jurisdiction allows continued development of new wells prior to, as a component of determining whether or not you're willing to plug and abandon wells in that jurisdiction?
Thank you again for your questions. As it relates to new development within a jurisdiction, as you are aware, with the technology that's emerged over the last 5 to 10 years, we have the ability to access minerals from various spots and still reap, a prudent and cost-effective development. And so in some instances where new development may be contemplated, that contemplation of that development may actually be outside that jurisdiction, but they could be deemed relevant, or proximate local government based on the 300 series rules, governing permitting. And so I don't have a real good answer to your question. We do consider all options relative to drilling new horizontal wells. And part of that equation does go into our current contracts and the obligations we have to maintain those contracts, as a fiduciary responsibility, if you will, to those mineral owners. As it relates to planned P&A, plugging, abandonment, and reclamation operations within these jurisdictions, yes, we do have plans to plug and abandon wells in the city and county of Broomfield this year. We have run into, admittedly, some high priority habitat considerations, specifically tied to nesting raptors that have delayed those operations and will push us into more of the third and fourth quarters of this year rather than midsummer. Off the top of my head, I can't speak with any definitive response as to whether or not we have operations scheduled in town of Erie or Boulder County at this moment.
Thanks for those responses, Mr. Bennett. And just to follow up a little bit, and I appreciate the upcoming plans to plug wells within the city and county of Broomfield that might demonstrate that Civitas does do so within jurisdictions that maybe aren't permitting new development. I just wanted to put a finer point on that first point and have it stated on the record. So I'll ask more pointedly, if a jurisdiction does not allow new development, is it the policy of Civitas to not plug and abandon wells within that jurisdiction until such new development is allowed?
I appreciate the clarification on the question, and by no means is that a policy by any stretch of the imagination, at least in my view. We do take that into consideration as we are planning new development to ensure that we are, effectively and efficiently developing the resource that is beneath our feet. But that is not a policy in my view.
Okay, thank you, Mr. Chair. No further questions at this point.
Thank you, Commissioner Ackerman. Further questions for the panel? All right, thank you, panel, for the presentation and the witnesses and the evidence that's been presented on docket 2211000285. At this time, we will move into the deliberations portion of this docket. And so would look to my fellow commissioners with regard to any deliberative thoughts. Commissioner Messner.
Thank you, Mr. Chair. I think I want to start my deliberative thoughts with kind of a reflection on the determination of how we got to option 6 financial assurance plans during the rulemaking. And while I believe that all of the commissioners who were not in that rulemaking have taken the time to review that, I think it's also good for all of us to go back and review the video of what was actually discussed during that financial assurance rulemaking, which I've had an opportunity to do. And as I looked at that, I think some people will recollect that I had a lot of heartburn with option 6 financial assurance plans, and ultimately was outvoted on the utilization of option 6 plans. But at the same time, I had more comfort and was able to have some inclusion in the rules in the option 6 plans of the reporting requirements that were going to be associated with the option 6 plans that ensured transparency and clarity as far as what the operators were doing that were realizing the benefits of the option 6 plans. And specifically in rule in the option 6 plans in rule 706, and I'm not going to find all the other ones, but the asset retirement planning is a big piece of this rulemaking, which indicates the demonstration of how the operator is planning for the retirement of its oil and gas operations based on the projected life of the field, the age of the infrastructure, out of service and active low producing wells, and related information, including for each inactive well, the operator will identify the reason for no or low production and the planned date to return to production or plug the well. And so that piece in there did give me some comfort in ensuring that the operators were going to be able to provide detailed and significant amounts of information for transparency on how their operations were going to be handling some of their lowest producing wells. And so therefore, I think created some comfort in the different stakeholders who are also concerned about the ability for operators to be able to access option 6 financial assurance plans. And so I brought this up in previous option 6 hearings, and I regret now that I did not bring it up stronger, because as I review the previous option 6 plans, I still think we asked for inadequate amounts of information to be able to meet the obligations that are included in the rule for asset retirement planning and documentation. And to this particular operator in their submittals, it appears to be that we're at a little bit of a race to see who can do the least, because we're bringing up other operators that we've approved and showing that this operator is almost there, but not even there to the previous submittals that we've had. And I think we're doing ourselves a disservice as a commission if we continue to allow the lack of detail necessary for this particular rule from option 6 plans. I think this operator actually qualifies for the option 6 plan. I don't think that there's an argument there. I think that there's been some points brought up here that may warrant close looks under the hood in future annual reviews, including I would recommend to commission staff that if necessary, that an independent financial review by a third party be performed to ensure that the financial metrics associated with this operator are appropriate. I've got no information in front of me right now that would indicate that, at least for the next year, that there would be issues associated with this operator. And so I do think that they meet the option 6 obligations, but I do not think that the submittals that have been provided by this operator are appropriate to be able to meet the obligations of asset retirement planning associated in the rules. I appreciate that the operator is willing to provide future disclosures, which is one of the asks from the parties here today. And I do think that whether it's an out of service list or not, the rule does clearly state that there is a demonstration for how the operator is planning retirement of oil and gas based operations based on infrastructure, out of service, inactive and low producing wells and related information. And particularly for each inactive well, the operator will identify the reason for no or low production and planned date to return to production or plug the well. I think the first thing that some of the parties have requested, which is additional information about some of the wells that have been spud and whether or not we're getting the information we need to be able to meet the obligations of this rule, I think is valid. And so And I also am concerned that we need to enforce our inactive well rules associated with the timelines associated in the rules and require single well financial assurance for wells that continue to be inactive after the 6-month period. That was a very contentious conversation during the rulemaking. And if we're not following up on that, and I'm not saying we are or we aren't, but if we're not following up on that, then I think we need to make sure that we are, to make sure that the single well financial assurance associated with those has actually been accomplished. And so I guess in short, I would recommend a few different things. So one, there's going to be an argument here that we've approved option 6 plans with less robust asset retirement plans than we may be asking from this operator. I would also state that I would expect a request from me in the future to see significantly more robust asset retirement plans, even from the operators who have already approved in the future, particularly during the next annual review, because I don't think now that we've actually met our responsibility for the asset retirement planning documentation and submittals. For this particular operator, I think what bothers me is that they actually go through a process that develops the very information on a quarterly basis that could be developed into an asset retirement submittal. And that level of information would be critical in order to be able to meet that rule requirement. And so it doesn't seem like a huge burden. It seems like we're just perhaps trying to do as little as possible. And so I would hope that we would be able to come to a decision to increase the amount of submittal requirements that would be required from this operator, level of detail in the submittal requirements. And that's going to be the gist of it. And then the other pieces, which is the enforcement of our inactive well rules for single well financial assurance. And if necessary, during the annual review, an independent financial review by an independent third party, if necessary, if the director determines that it's necessary to ensure financial health of this operator. So those are my initial deliberative thoughts. I appreciate the time.
Other commissioners with thoughts? Commissioner McGowan, you're not going to go last this time, huh?
Oh, lucky you. So I have a couple of thoughts too, and I don't know if I'm completely aligned with Commissioner Mesner. After we just dug deep into own operating financial assurance, I think anything feels like financial assurance light after that. If I recall conversations about the option 6, it was that these companies are large and already submitting audited documentation to the SEC, and that would be a surrogate measure for financial assurance, and knowing that a third party had looked at their viability or their standing, lower risk, et cetera. If I'm misremembering that, please feel free to correct me, but I thought that was part of the conversation, and feeling then having more confidence about the viability of the operator because it's already submitting documentation through a federal process. That being said, I guess I'm going to focus on the inactive well and the out of service well pieces, and I would like to figure out if we can get updates from the operator and more specifics as they move forward to ensuring that these wells are on track and that they're doing what they're saying they're going to do with them, so that we know wells on the out of service list are getting plugged and not at the final and last date, and that inactive wells are not sitting in inactive purgatory, that something is happening with them also. I do think this operator is an option 6 eligible operator, and I think that they've met the requirements of the rules that we have for it. So those are my thoughts.
Other deliberative thoughts, commissioners? Commissioner Cross?
Thank you, Mr. Chair. And I want to thank all the parties here for taking the time to go over with us today, because I do think that financial assurance is a very important part of what we need to do as a commission and ensuring that we clean up our act. And I think that, you know, it's important to make sure that operators are also being held responsible to stakeholders within the state. And so I do appreciate the petitioners coming in and providing us additional information and some of their concerns that have arisen as they've gone over this. I'll start off by saying that I do think that this applies to an option 6 plan. I think that they clearly meet the basics of the plan, both with the production amounts and with it being a public company. I will say that with respect to some of the looking at a potential third-party financial accountant to look at things in the future, I think you already get that, because this is a public company that has to use an independent auditor for their 10Qs and their 10Ks. I think we already get that financial review from an independent auditor, and I don't think that we as a commission need to spend taxpayer dollars for that. I do understand and appreciate the especially Ms. Denomy's testimony with respect to the volatility of it. I think that is not anything new. When you look at some of the amounts and the discrepancies and cost of gas prices between 2022 and 2023, you also see similar discrepancies between 2021 and 2022, and even in 2021. And if you look back even further, they still do have built into their budgets the amounts for short-term and long-term asset retirement. They still do have built in, just based on the amount of current assets, current liabilities, long-term assets, long-term liabilities, the ability to pay for that. And so I think one of the things that's really interesting for me with this application is that when we get to the basis of what we're trying to look at for financial assurance, and will Civitas be able to meet their obligations to plug, abandon, and reclaim well sites and facility sites in the state of Colorado? I think that using the option 6 blanket bond that we have here of $40 million, that's undoubtedly yes. When you look at the numbers of what the low producing wells are, the inactive wells are, that $40 million is without a doubt going to cover those wells that are at the greatest risk of needing to be plugged in the immediate future. I think that's, to me, a different question than how we are looking at the plan that Civitas is moving forward to accomplish their plugging and abandoning program. I think it's a different question than how Civitas is interacting with local governments and being transparent about their plugging and abandoning plans. And so that's the biggest struggle for me here. Because when it comes to the financial assurance to ensure that they have the capability to cover those obligations, I think that's absolutely met. And I think the $40 million, as Ms. Ryan showed, when you compare it to an option 1 plan, you're talking about a fraction of the cost, actually. And so I think it is a benefit to the state to have that $40 million plugging bond. Should you have significant volatility, should you have situations where additional wells get put in that need to be moved to low producing or inactive or need to be used for plugging and abandoning, that's a far better situation for the state than doing this under an option 1. That said, I think that there needs to be some soul searching to a certain extent to work on transparency with stakeholders, with local governments about what's happening here. And I see this, I don't want to limit this to what's happening in this hearing today, but I think there are situations where we as a commission get complaints of, well, we're not really sure what's happening, and information that's provided in applications is lacking. And it could be information about discussions with landowners. It could be information about providing information to staff with OGDPs. It happens in several situations, but oftentimes it's information that the operators do have and have prepared in case it's asked about during commission hearings. And when it's information that, as Commissioner Messner said, this is something that could be provided, this is something that is already prepared, why is it not something that is provided more willingly to stakeholders, to staff, to the commission at the outset? And I understand that in certain circumstances, there's going to be situations where there's confidential business information. And I think that that can easily be handled with redactions. It can be easily be handled by saying, here's what we're willing to provide that's not confidential business information. But when it comes to situations of, you get stakeholders that are asking for more information with respect to, are we going to see this coming back as an active well? Is this going to remain out of service? Is it going to be inactive? Or do you have plans to plug and abandon this? And I'll be honest, I think even some of the back and forth about Mr. Frank saying, we're kind of told, well, we'll plug and abandon when you're ready to drill some more wells. And I think for a lot of people listening in, that sounds nefarious. It sounds devious. And ultimately, I think what happens a lot of times is you have to have a well holding production for a lease. And so if you're going to get rid of an older well, there are times where a new well has to be drilled, and it can be a better, more efficient well that's going to have less emissions and everything else. But until that new well is drilled, you can't plug and abandon that older well. And that in and of itself is not nefarious. It's not devious. It's not any kind of issue, but just that lack of communication back and forth of, this is why we're saying we need a new well. If you want to get rid of a well over here, if you want to get rid of a vertical well that's closer to a potential development, this is what we need to do. And that's something that can be worked on with increased transparency, increased communications. And it's frankly a little frustrating that it has to be pulled out in a situation such as this. So I'm going to step off my soapbox here for a little bit and say, ultimately, when I think it comes to the financial assurance plan of this, I think that they do meet option 6. I think that the applicant has shown that their financial situation is good. I agree that I think this should be looked at on a yearly basis. If part of the concern is we just want to make sure they're going to remain financially capable of keeping up with their obligations, I'm fine with that. And I think it's a good way to say, hey, let's continue to look at your plugging and abandonment and reclamation plans to make sure that you're keeping on track with not what you've done in the past, but what you need to do moving forward. And so I think I would be in favor of approving the plan, but I want to make sure that it's known that I think we just need to make sure we have some increased communication, some increased transparency on things that we can't provide that transparency on.
Yes, Commissioner Ackerman.
Thank you, Mr. Chair. I'll be very, very brief as my comments are very closely mirrored of Commissioner Cross's comments. And I would just make 2 statements. And the first one is that I think, communications regarding plugging of wells and sharing of information is so important, but it is different from the question of whether or not Civitas has met the requirements of this financial assurance hearing in my mind. My second point is I am concerned about communications and the lack of proactivity of providing information by this operator specifically. I also felt the same feelings during the Civitas OGDP hearing docket earlier in this same meeting yesterday. The goal should be zero communications problems to the extent that you're not sharing confidential business information. And I would ask Civitas, don't wait for the stick to be raised before being responsive. This approach is one that drives wedges between parties and increases tensions associated with the industry as a whole, and it creates difficulties even broader than the discussion here today brought forward by the petitioners. I want to specifically encourage more willing disclosures and stakeholder coordination, and call for specific action to ponder that on the part of this company. That said, Mr. Chair, I think that's all I have to say.
I think, well said, Commissioner Ackerman, and I think we need to take that message to the folks at Civitas. Ms. Ryan, you're here representing Civitas in a matter, but I think we'll try to have that discussion with other leaders from the company. Okay, I too think this application meets the tenets of option 6, and I believe that Civitas ought to do a very good job. There should be zero communication problems, and that is with its stakeholders as well as its local governments. With that, does any commissioner desire to make a motion? Commissioner McGowan or Commissioner Cross?
I would just say I'd move to approve the option 6 financial assurance here. I just want to make sure that we, and perhaps AAG Mercer can speak to this, but make sure that we include the yearly as opposed to every third year update to the commission in terms of how the plan is being updated with respect to updated financial information, updated well information, and updated plug-in and abandonment plans.
AAG Davenport?
Thank you, Chair. I'll admit to having tried to do two things at once. So I think the motion is to include or to approve Civitas's option 6 plan as presented with the yearly update. But I would like to be sure that it's clear what was included, what is to be included in that yearly update.
So from my view, and I definitely entertain comments from my fellow commissioners, but make sure that we have updates on plug-in and abandonment plans, updated financial information, which should be easy enough with their 10Qs and 10Ks, as well as any changes to inactive, out of service, low producing number of wells.
Commissioner Messner?
Thank you, Mr. Chair. So I had heard clearly that Civitas was willing to meet Mr. Foot's request around future disclosures that include some of what you're talking about, which includes P&A reporting. But Mr. Foot was very specific about what he was asking, and I heard Civitas, I believe, indicate that they would be willing to do that. In addition, we've asked in the past for a narrative around their asset retirement planning that clearly develops significant additional detail associated with their asset retirement planning, different than, individual dates, all on the exact same date for the entire list, and all the exact reason, which are 2-word reasons. Even Mr. Bennett at this point has been able to give us definitions of what the 2 elements within their asset retirement plan wording meant, but that wasn't included in their submittals for the asset retirement planning. And so that would be what I would request be included in this motion, is that level of detail in future annual asset retirement planning reporting, including the number 3 that Civitas has agreed to from Mr. Foot.
Okay, so Commissioner Cross, are you comfortable with that friendly amendment?
I am.
Ms. Ryan, can you put together a sentence or two that describes in particular the sort of the foot thing that you've agreed to? Or have you done that?
No, but I can put that together. Yeah, and I mean, it's really just the same as what I understand the commission to have previously required of other operators. So it's an annual summary of its progress on its out of service plugin list, was specifically what we agreed to.
Commissioner Messner, is that compatible with what your impression was?
My understanding of what Mr. Foote asked for is that that would be compatible with his request. Yes. I will, indicate that the second piece that I am asking for the commission to consider is updated asset retirement details and narratives that would indicate better timelines, better details, better reasons associated with the actual rule that is required for option 6 for their asset retirement submittals. I would request this from this operator as soon as possible, as far as their submittal goes, understanding that this level of detail may not have been asked of the 2 previous option 6 operators, but that I will request in future submittals from that operator during the annual review, because I think it is our obligation to get that level of detail as far as their asset retirement planning under the rule. And so that's my ask. It doesn't seem onerous. It seems right in line with the rules. It seems right in line with the discussions that we had. And it really created significant amounts of comfort with option 6 from a lot of different stakeholders during the financial assurance rulemaking. And I think if we're walking that back and not requiring that level of detail, I think we're doing ourselves a disservice.
Commissioner McGowan?
Thank you, Mr. Chair. Commissioner Messner, could you, I don't know if I disagree or agree, because I'm not sure when you say you want more financial assurance narrative on the asset retirement. I'm so sorry, I'm a little brain dead also, but if you could talk about what that looks like and what you want to see, I'm going to guess that I'm supportive.
So the rule, and it's 702, and I'm not going to get this exactly right, but 702 B6 Roman numeral 5, I believe, which is under option 6, the asset retirement planning rule. And it indicates a demonstration, right? So demonstration is an important word in this. It's a narrative. It's a performance-based requirement that indicates of how the operator is planning for the retirement of its oil and gas operations based on the projected life of the field, right? So I haven't seen anything in any of the asset retirement plans that we've seen so far that even talks about the projected life of the field. The age of the infrastructure. I haven't seen anything in asset retirement planning submittals that talks about the age of the infrastructure, out of service wells, inactive and low producing wells, and related information. So it needs to tell a story of their asset retirement planning with a level of detail that is not that is something significantly more than one date for every single well in their asset retirement planning submittals, as well as one reason why there's a number of inactive wells in their portfolio. It also indicates in there specifically, and this is verbatim, for each inactive well, the operator will identify the reason for no or low production and the planned date to return to production or plug the well. And so that to me is, again, well specific and requires a level of analysis and detail on a per well basis that is a submittal requirement in their asset retirement plan for them to be able to meet the obligations of the rule. I'm not making this stuff up because I think that it sounds like a good idea. I think it's very clear in the rule what the ask is.
Commissioner Messner, not to try to simplify this too much, but I mean, couldn't we make reference to the rule in our motion? Because it all seems to be there.
I mean,
And I think,
don't disagree.
yeah, and I think what we're missing is that we didn't have this robust discussion in the other two, but it's in the rule. And so I would suggest we make it more simple and just with asset retirement reporting consistent with the robust requirements of Rule 7.0, whatever it is. Commissioner McGowan?
So sorry, so I'm gonna guess that the operator submitted in a way that they thought they were meeting the rule. That's why it's been submitted. So I think we need to be specific about what they are not meeting in the rule that Commissioner Messner was just talking about. So if there isn't enough narrative talking about the life of the field, the age of the infrastructure, and the estimated retirement timeframes within which they will be dealt, that I think we need to be specific that that's what needs to get added. So it's, to me, I think what I hear Commissioner Messner saying, and I think it's appropriate, right? That the out of service list, which we also pointed out to the other operator, does not feel like a lot of time and effort was put into. What exactly is going on with that well? Why is it on the list? When are you going to take care of it? And in this case, we're having the same issue with the inactive wells. And then I think what I hear Commissioner Messner saying, and Commissioner Messner, I don't want to speak for you, is there just isn't a general overall picture of the assets in their totality in a narrative format about the age and how the operator is planning for overall retirement when all those wells have to be dealt with and retire, just like we went through with own resources. I hear what you're saying. I'm just trying to figure out how we're clear to them what it is that we want so that they're going to meet expectations.
But I mean, well, yes, what you're saying is correct, and I appreciate you telling it back to me because I think that helps us communicate, and so I think that's good. It's not our burden to meet the obligations of the rule. It's the applicant's burden to meet the obligations of the rule. I think that this discussion that we're having right here would hopefully make it very clear to the applicant what submittal requirements would be required in order to meet the obligation to the rule. I think plain language reading of the rule, as Chairman Robbins has indicated, would clearly indicate that the submittal requirements provided by this operator are inaccurate. I do support Chairman Robbins' proposal to actually read the rule into the motion so that it is clear to the applicant and reference that does need to be robust and needs to be based on deliberations that have occurred here today, both from the parties who brought this up, as well as the commissioners themselves, because I think that we've indicated the level of detail that needs to be provided. But ultimately, the applicant needs to submit something and we need to make a determination whether or not it's meets the rules or not. And that's performance-based, rules. And so it's not prescriptive, although it is certainly prescriptive with very specific things in there that were not met. And so there is a level of prescription in there that I think is important, but I'm not sure that there was the robustness associated with the submittals in this. And so I would make the friendly amendment, as Chairman Robbins indicated, to include the rule language in our motion.
All right. You good with that second friendly amendment, Commissioner Cross?
I am. And I'll just make a note. I think when you look at the Form 3 and the information submitted with the financial assurance application, I do think that there is some information on the projected life of the field, on the age of the infrastructure. It doesn't go into a lot. And I think one of the things that's important is, and I know this has come up in the past too, is trying to set the firm dates of when it will be plugged and abandoned by. I also recognize that changes. Information changes based on local governments providing input, et cetera. And so I think it probably makes sense to say, to even say, instead of a specific date by which they're going to do it, say, here's kind of our priority list of what's going to be plugged and abandoned next. And I think kind of as clarification when we go into it, as Commissioner Messner said, I think when you look at the inactive well list and it says commerciality midstream and the questions that we went over with Mr. Bennett, it going into information such as the reason this is listed as commerciality midstream is because the cost of being able to put this into a midstream under the correct pressure and whatever requirements is required by the third party vendor that's doing the midstream, it costs more than what it's worth right now. I don't think it has to have, you have to have a paragraph written for each single well, but I think you can provide additional information which explains why this is listed as commerciality midstream. So I'll just say that, but I am comfortable with that friendly amendment. Yes.
Okay. AG Davenport, not to put you on the spot, but you're a lawyer, so I get to put you on the spot. Can you try to summarize? It's a motion to approve the option 6 plan with, I think, 2 adds.
Yes. This is what I've got. Motion to approve the plan presented by Civitas with 2 additional points. First, yearly updates that include plugging and abandonment plans, progress on plugging and abandonment, updated financial information, and any changes to inactive, out of service, or the number of low producing wells. And also included in that yearly update would be and a reference to Rule 702 D6A5, a narrative that complies with that rule I just cited. So all of that would be part of the yearly update. But as what I heard is Commissioner Mester would also like on a narrative that complies with Rule 702 D6A5 as soon as possible, I believe, and maybe I misunderstood that part.
I think I heard that as well as a condition of approval of this financial assurance plan. Commissioner Messner?
Thank you, Mr. Chair. That is what I'm asking for as part of their required submittals for the approval of this plan, is to have that. I understand it will take some time to do, so I'm not trying to hold anything up, but I do think that's an important submittal for my approval of this option 6 plan.
Okay. With that reiteration of the motion, as well as the conditions of approval, Mr. Cross, are you comfortable with the motion as read?
Yes.
All right. Do we have a second?
Second.
All right. We have a motion and a second. Before we have additional discussion, I did note that Ms. Ryan had raised her hand just a little while back, and she thinks she's put her hand back down, but I did want to give her an opportunity to speak to the motion with the conditions if she felt that necessary.
Thank you, Chair Robbins. I was just trying to clarify if the requirement for the asset retirement plan enhancements or amendments was supposed to be in the annual update or on the sooner side, as Messner just clarified for us. So I believe I understand things, and I'm just checking in briefly with my client to assess the possibility of, thinking about timelines. But so long as you understand that it can't be exactly immediate, because, as Commissioner Cross said, we did think it met the criteria of the rules. We'll need a bit of time thinking how we can retool this into a format that's easier to understand for everyone and contains more information.
Right. And I think our motion does not put in a firm time frame. We would just, want it to be done in a reasonably, business-like manner, and we trust that you'll get that done. So I don't know that we need a response back on the specific time frame. At least I'm comfortable that way. All right, we have a motion and a second. Is there further deliberations on the motion? All right, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries. All right, thank you very much, Mr. Ryan, to you and the Civitas team. I want to also thank Mr. Foote, Mr. Sullivan, and Ms. Burke, as well as their witnesses for their information they brought to the table. I think that we echoed as a commission uniformly that there needs to be zero communication problems with local governments. And I encourage you to reach out to me as chair if things continue to not work as you think they ought to, because I think that's a really important component to the interrelationship that we've created between the COGCC, local governments, our operators, and our stakeholders. So thank you for your community's involvement in today's proceeding. I know you didn't get everything you wanted, but the message was heard loud and clear, and we want to make sure that we continue to be responsive. So thank you.
Thank you, commissioners.
All right, commissioners, let's take a 10-minute break. We're going to return at 3:15, and at that time, we will see if staff and the OWN folks have been able to work on that matter for our final consideration. So 3:15.
Okay.
All right. I think we've got all commissioners back. This is a continuance of docket 2211000287. It is Thursday, June 1st, and it is 3:44 and 48 seconds in the afternoon. So with that, AG Davenport, would you like to orient us?
Thank you, commissioners and chair, and we appreciate your indulgence and the time to get this together. I'm going to share my screen, and it does have language on it to be inserted into OWN's financial assurance plan that I believe addresses the commissioner's comments. And if you would give me one moment to make sure I'm about to share the correct screen, I will do that. Okay, you should hopefully now see, I'm making it bigger, a document that starts with a paragraph 14, OWN's proposed financial assurance plan. I'm going to scroll down because until subparagraph F, I believe this already appears in OWN's proposed plan. Subparagraph F is what was added to respond to the commissioner's requested additions. And I'm happy to listen to suggestions as to how to take a look at all of this. It goes on for about another page. So I can leave it on the screen. You can all read it and then let me know when you're ready for me to scroll down.
Okay.
But if you've got alternatives, let me know.
I'm just wondering, at least from my perspective, I'd love you to email it to me. And then I can just pull it up on my computer and scroll.
Okay.
I'm
I'm happy to do that too. I'm going to stop sharing so that I don't inadvertently disclose something on my screen that.
I mean, other commissioners may want to look at it on the screen, but maybe if you email it to all of us first, then we can determine which is the right route.
Okay, give me 1 second to get that email out. And then I'll put it back up on the screen.
Yep, perfect.
I just sent it to you. I will get it back up on the screen now. So as I said, the first part of this document, paragraph 14, subparts A through E already appear in OWN's proposed plan. Subparagraph F is where the language that was added in response to the commissioner's requests starts, and it goes through subparagraphs G and H. The red line is something that is in red line just because I added it to what Mr. Lepore sent to me earlier today.
So subparagraph F and then to the bottom is new, even though it's not redlined.
Correct.
Okay.
I still don't have it. Did everyone else receive it?
I didn't get it either.
It's in my sent folder. I can't. Hopefully it shows up soon. Is this, if I make it a little smaller, maybe you can see more, is that too small?
No, that's okay. Why don't you scroll down? Okay, I just got it in my email.
Okay, good. I did scroll down. This is now the next part of, and actually,
AG Davenport, under G, Romanet 1, 2, 3. Are those the events that need to be reported?
yeah, those, the intent is G1, 2, and 3 are the 3 triggers that would result in reporting to the director as the first part of G relays.
I think it might be helpful to have a new small sentence after the word issue. The events reported under this subparagraph G are :
Mr. Chair, I'll propose an alternative, which is
Go ahead.
you put the Romanets 1, 2, 3 after the first sentence. Owen will report the following events to the director. Diligence, semicolon, 1, 2, 3, and all the other text can come after that.
That's fine.
Ugh.
That's going to require.
It's only funny to some of us.
Okay, it's not great in red line. I can just take it out of red line.
I think we did one too many deletions, and that should have been H.
So I think I've kept the letters correct. And then what, this could be H2,
Yeah.
H also. We can clean up the formatting.
Yeah, that's fine.
Later.
Can I ask
That's
Mr. Lepore a question?
You may, Commissioner. I'm sorry. I was trying to talk and I was on mute. There's a typo in Romanet 2, I believe.
The word other?
Yep, thank you. The word other should be otherwise. And then I think the sentence here, you can't see my cursor, maybe, yeah, you can't see my cursor. Owen may propose a plan. I think that is part of G and should not be made part of a new anything.
Yeah, I agree.
Okay.
And then Director Lepore or to Mr. Schneider or Pfaff, the 3% for inactive and the 15% on purchases or otherwise acquires. Can you provide some perspective as to those percent numbers and where they came from?
Chairman, I'll start and Mr. Pfaff can weigh in if he likes. The 15%, we're just trying to find a number that we would consider sort of material or substantive. You know, if Owen with 3,000 wells buys 25 wells, the meter doesn't move very much. So that's kind of, you know, we batted some numbers around. If they bought 450 wells or sold 450 wells, that probably moves the needle. The inactive count is a function chiefly, I think, of there is going to be a small inventory of inactive wells, as Mr. Pfaff articulated earlier. You know, there's an economies of scale built into when do they hire a workover rig. Doesn't make sense to hire a workover rig to P&A 1 well or 5 or 10 wells. So there's a number there that is ordinary course of business, and there's a number there that becomes an event, to use the words of the language here, that is out of the ordinary, that has an impact on this financial assurance plan. In our minds, that was 3%. That would be something like 90 wells on its inactive roster.
Okay. For the commissioners that had expressed sort of conditional desire for this language, does anybody have questions with regard to the language that we have other than the questions I've already raised? Commissioner Ackerman?
Thanks, Mr. Chair. Just a couple of suggestions as well, and these would be found in sub F under 14 on the first page. And down below Roman numeral at 1, a review of its asset value and projected field life and well lives. I was hoping for something more than just a review of the asset value. I think, can we add something in there that says something to the extent of a detailed current financial capability statement? And then it would include the review of its asset value, and also I think should include the value or the amount within the sinking fund. And then I just wanted one clarification at the end of that same bullet. It says projected field life and well lives. I think the intent there is to give an accounting on an individual basis on each well life, right? I don't want it to be considered to be a collective. In general, our well lives are between X value and Y value. And I think that's the intent.
Sorry to interrupt. Do you mind doing that in red line?
Yep, good idea. Thank you.
So a detailed financial health analysis or financial capability, to use the terms that we use in the regulation, including, and then where it says a review of its asset value, a statement that requires the disclosure of the current amount of the current balance in the sinking fund. And then the last part of that is, can we clarify somehow under the projected field life and well lives statement that it's, you know, an analysis of each individual well life. So you could put projected field life and individual well lives. To me, that'd be enough, I think. And of course, those are my suggestions, and certainly open to discussion from the operator here. I think that encompasses what I had in mind.
Why don't we do this? Any further edit suggestions from commissioners to the language? What I want to do is get it all kind of on the table and then give Mr. Lepore and his clients an opportunity to huddle amongst themselves to consider any changes. Is that fair, Mr. Lepore?
Yes, sir. Thank you.
All right, I'm not seeing any further suggested edits at this time. How do you want to handle this, Mr. Lepore?
I think we could simply mute and blind ourselves and get on a phone call for a little bit. Or I could read my text messages in which my client says we are good. And we could go from there.
Very good.
So I think we're
All
good.
right. So with that, we are in the deliberative stage of this matter. I believe at this point, I would look for a motion from commissioners that adopts this language, knowing that we're not all on the same page, which is a healthy place for us to be at times. Does any commissioner desire to make a motion?
So moved. I moved that we adopt this language.
And approve the option 5 proposed plan.
And approve the option 5 proposed plan.
Okay. AG Davenport, is that sufficient? Is there anything? It's been a long 2 days. Is there anything we're missing at this point?
No, I don't believe so, Chair. I think if I can be so bold as to restate the motion to is approve the option 5 plan as presented by OWN with the additions discussed today in subparagraphs for 14, F, G, and H.
And to show that I really am tired, was there anything else, and I'm looking at you, Director Lepore, that your clients had committed to as a result of a day and a half's worth of on this, or does this capture everything? We just did another financial assurance plan, and there were changes there too, and I just don't want to miss anything. I don't think there's anything else, but I just want to dot that I and cross that T.
Yeah, Mr. Chair, we took the first cut at this at the request of AAG Davenport, who had other things to do, like attend your last hearing. We tried to capture everything that we had in our notes. We sent that over to AAG Davenport and Director Murphy. And this was the result of that. So I believe we have it.
Yeah, and I'm just looking at my notes. I believe that the asks that were made are comfortably captured in this motion. With that, is there further discussion on the motion? Commissioner Messner?
Thank you, Mr. Chair. So with all respect to this operator, because as I indicated in my comments, I do believe that this is a good operator and is a good operator for the state of Colorado. But I will be a no vote on this plan for the reasons that I indicated during deliberations, as I strongly believe that the plan as presented does not meet the intent of the rules that were developed during the financial assurance rulemaking. And with all due respect to my fellow commissioners, because I respect each of your opinions, I am concerned that the viability of our financial assurance rules really lie in the decision-making of this body, as we provided significant discretion that was a concern for a number of people during the rulemaking process, that we did allow ourselves that level of discretion. And so in my approach, I tried to be very cognizant of that in making sure that I was applying the rules, both as the intent of the rules as well as the letter of the rules. You know, in this particular situation, I am worried that we, by approving this in this format. Now, I do believe that this operator is a possible option 5 operator. I do believe that. I just think that the proposal in front of us does not meet the obligations of the rules. And I fear opens the floodgates to other significant amounts of operators that will see this as a window to be able to develop plans that require less financial assurance than what the rules we developed require. I say that again with all due respect. I'm not discounting my fellow commissioners' opinions, but these are the reasons that I'll be voting no.
Appreciate the comments, Commissioner Messner. Commissioner Ackerman? I was going to respond too, but go ahead.
Thanks, Mr. Chair. I'm happy to wait for your response if you'd prefer to go first.
No, go ahead.
All right, thank you. I just wanted to add some context to my thinking as well. And as I stated during the open discussion, I'm not entirely convinced that this is the right amount of financial assurance. I am convinced that option 5 is the right place for own resources to be. I can't think of a better company, honestly, to pilot an option 5 plan than own resources. And I agree with Mr. Lepore's early statements that this operator does fit within what I consider to be a very narrow scope that fits within option 5. Certainly, as Commissioner Messner stated, all due respect to him, I'm very concerned about setting a precedent as well, and I'll talk about that maybe in just a second. But I am willing to consider an option 5 plan initially at the financial assurance amount that's been proposed by OWN, specifically as a pilot with the stringent review processes that we've outlined. And I do reserve the right to reopen the discussion during any and all of those review processes about the amount of financial insurance that OWN should maintain. And I feel like, you know, if we're going to have an option 5 plan, we don't have a prescriptive formula to create that right number. I think we do need to start somewhere if we're willing to go down the road of an option 5 plan. What pushes me over the edge into allowing this approach is largely threefold. First, OWN's unique structure of holding a large number of total assets, but almost all of which are low producing. Second, OWN's very responsible practice of immediately P&A and R-ing wells rather than maintaining any substantial inactive well list for any length of time is significant to me. And third, OWN's unique, strong financial position and significant long-term financial projections are very unique for a majority low producing well owner. So as I stated, I think OWN's model provides a valuable service to the people of the state in a niche that's not significantly occupied by any other operator, and I expect that its responsible and proactive plugging and reclamation processes will continue. And I'll be closely watching the sustainability of what I will consider an option 5 pilot, if approved. And lastly, if this plan is approved, whether specifically intended or not, the result will be, as Commissioner Messner pointed out during deliberations, a lower amount of overall financial assurance paid compared to what would be paid under the option 3 approach that OWN fits into formulaically. And I agree with Commissioner Messner that this will undoubtedly result in other companies proposing option 5 plans to the commission and making the argument that the full single well financial analysis required under option 3 does not serve their business models well either. Again, what makes OWN unique in my mind is the gross number of assets that they have is similar to the larger companies, but the total production of those assets, as well as OWN's total low overhead due to no exploration or drilling, are significantly lower than those larger companies. So if the regulatory formulae are followed, this unique situation would result, as we saw in an option 3 plan that would require single well financial analysis or single well financial assurance, that ultimately, in my opinion, inappropriately results in financial assurance amounts akin to the largest companies operate in Colorado. But because of its number of assets and the breadth of its operations, even though they're low producing, an option 5 plan would still require that a considerable amount of total financial assurance would be carried by OWN, as opposed to an operator maybe that just had a few wells, in which case single well financial assurance, I think, would be more appropriate. I really don't expect this model to apply to those operators who hold relatively few resources and or those that drill their own wells. I believe companies in that situation will most appropriately still fit into the full single well financial assurance model that's set forth in option 3. And I certainly don't intend to set any precedent by which operators who formulaically fit into option 3 can now default to option 5 through acceptance of this particular motion. That's easier said than done. I do have concerns that we will face a bevy of these, and it's important to me to get out on the table why I think there's a very narrow scope here that OWN fits within, and I'm willing to go down this road. And I hope that it's the right road. It's a big thing, like Commissioner Messner said, and it's a difficult road to go down.
Thank you, Commissioner Ackerman. Commissioner McGowan.
So maybe I'm somewhere in between, but if other operators want to open up their sock drawer the way that OWN Resources has done with this commission, I'm not sure that many of them are going to be able to show us the same fiscal rigor and insight that OWN has showed us, which is why I'm willing to take this leap and, like I said earlier, take it for a test drive and see how it works. I think that they've shown us that they're a responsible operator. They're in good financial standing. They have a very low number of inactive wells. They've been P and Aing their wells as they reach end of life. They're coming up with a unique plan to try to address something that will work for them as far as financial assurance. They've shared with us the life expectancy of their wells, which arguably is more than what was shared with us in the last hearing we just had. So I'm supportive of this, and I think that they've shown that they fit into this option 5 and why they fit into it. And if other operators are going to try to follow, I think the bar has been set pretty high as far as what they've shown us with their finances and the status of their assets.
Commissioner Cross.
Thank you, Mr. Chair. I think similarly, I think that, you know, the breadth of information provided, and I delved into this topic a little bit during my earlier deliberations. I think that, one, it's important to note that all these plans are done on an individual basis. I don't think that there's necessarily precedent being set by any of these, because each plan is so focused on individual company financial stability, financial planning, plug-in abandonment plans, locations of where they are, assets of what they have. I think there's just so many things to it that it's hard to set precedent. I do appreciate that there will likely be some operators that want to file option 5 plans, and I think many of them initially thought that's probably a good idea, but as said, I think that the information provided is the type of information we need to consider approving an option 5 such as this. I think the one thing that I'll say with respect to my disagreement with Commissioner Messner and I appreciate where he's going with this, because I do like to follow the letter of the regulations. I think where I feel a little bit different in my interpretation is in the statement of basis and purpose. I know that he highlighted that it specifically talks about the commission intends that the operator will meet the single well financial assurance obligation of its low producing wells based on the production threshold and all allowances of the standard option structure. And I don't disagree with that. I think that what you see in the difference between what the rules actually require and what the intention in the statement of basis and purpose, though, is not a requirement that they follow that low production threshold. And that's where I think that this option 5 plan has the ability to go. And we did talk a little bit about unreasonable or unnecessary. I don't think that the option 3 was unreasonable. I do think that it was unnecessary based on the reservoir reserves, the financial ability, and the plans put forward. So I think because it is unnecessary, I do think that the key for me is that single well financial assurance obligation of its low producing wells will be met. It's just met in a different way than the formulaic bases of what's provided in options 1 through 4. But I do agree with my fellow commissioners. I think that this is, the amount of information put into this makes this somewhat of a unicorn. And so I think as a warning to other operators, I don't think this is something you should look at as precedental. And it's something that you should, whether you're doing any kind of demonstrated costs, this is something that you should look towards as an example of how demonstrated costs should be put forward. And in case there's not a second, I would put a second out there, just as an FYI.
Yeah, I believe we have a motion and a second. I appreciate all the comments from our commissioners, and including the comments from Commissioner Messner, with whom I don't agree in this instance. I do not believe this is a floodgates problem. I think option 5 is by its very nature not a floodgates problem. I do think that today's action, if this is approved, breathes meaning into option 5. And I think we meant for option 5 to have meaning. I do not believe we're going to find too many operators that can provide all the evidentiary support for an option 5, as was done by OWN and at least this commissioner's perspective. So with that, and seeing no further deliberative vote comments, all those in favor signify by saying aye. Aye.
Aye.
And all those opposed signify by saying no.
No.
Motion carries 4-1. The option 5 plan with the adjustments is approved. Want to thank you, Mr. Lepore, and your clients for the vigorous work. I also want to thank the staff for the analysis that was put into it. I agree with Commissioner Messner that I found that to be helpful to us as we reviewed this. We will look forward to annual reviews with OWN resources. The check-ins, we'll see if this pilot is flying appropriately. And so with that, I think we have concluded the business of a long 2 days before the commission. We look for a motion to adjourn.
Thank you, Mr. Chairman. Thank you, commissioners.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
We are adjourned. Thank you, everybody.